Hello everyone, this is Sasha Cisco, and you're listening to the Ultradelic podcast. Our premiere episode, entitled Florida Ayahuasca Churches, Religion and Law, is a two-parter. On the first installment of this podcast, I'll be discussing how Florida's religious freedom laws implicitly ban plant medicine churches, as well as so-called magic mushroom ministers, ayahuasqueros, and even chapters of the Native American Church. Yeah, you heard that right. And in the second installment of this podcast, I'm going to be discussing one particular ayahuasca church that's only a short drive from Disney World. And, gotta say, what a small world we live in, huh? Now, the DEA has just flatly denied their petition for religious freedom, and the fate of all American ayahuasca churches hangs in the balance. And in that second installment, I will make it clear that if the plant medicine community does not stand together and denounce unethical psychedelic facilitators, I fear that we will face a tsunami of sensationalist media reports demonizing ayahuasca and other psychedelic substances, not unlike what America saw in the 1960s. Now more than ever, the community of psychedelic researchers, journalists, and advocates need to end the silence on these topics. Now, before we get going, I do want to make it clear that all information provided within this podcast does not and is not intended to constitute legal advice. Instead, all content contained within this podcast is for general informational purposes only. Just as a warning, this podcast does discuss topics that some viewers may find offensive. And these topics include, but are not limited to, substance use, politics, Richard Milhouse Nixon, unethical psychedelic facilitators, and adverse drug reactions. This podcast does not encourage the illicit use of psychoactive substances where they are prohibited by law. This podcast also contains links to other third-party websites, and such links are for the convenience of the listener. This podcast also discusses ongoing criminal and civil suits, so this podcast may not include the most up-to-date information. To my knowledge, however, there are no gag orders that would prevent journalists from discussing these criminal and civil suits within a public forum. Just as well, no individual or organization should act or refrain from acting on the basis of the information derived from this podcast. Material in this podcast should not be used as a substitute for personal consultation with appropriate professionals. If anyone wants an attorney's perspective on these topics, then seek legal advice from a board-certified attorney. Use of and access to the information contained within this podcast shall not establish an attorney-client relationship between any parties. To be clear, I am not an attorney, and I've created this podcast solely to inform the broader community about the topics contained within this podcast. Now that we're through that, just to make it easy for my listeners, I have 4 goals for this podcast. First, to give my audience a better understanding of the concept of religious freedom as it pertains to American jurisprudence, while also raising awareness about how psychedelic substances can be utilized as bona fide sacraments within plant medicine churches. Second, to inspire listeners to ask themselves these 2 questions. 1. Should plant medicine churches be liable for damages sustained by congregants during ceremonies where psychoactive sacraments are employed? 2. What should the psychedelic community do when psychedelic facilitators are accused of wrongdoing? My third goal for this podcast is to critique Chacruna's and the Council for the Protection of Sacred Plants' newly released Guide to RFRA and Best Practices for Psychedelic Plant Medicine Churches. Specifically, I have 2 points of contention which I aim to address in my critique. 1. Contrary to the information provided within their RFRA guide, Florida does not have a mini RFRA that shields the sacramental use of entheogens within plant medicine churches. 2. While I agree that liability waivers could benefit plant medicine churches insofar as providing informed consent for congregants, I disagree with the verbiage that Chacruna and the Council for the Protection of Sacred Plants have suggested to be utilized in said liability waivers. Without going into too much depth, I believe that the suggested verbiage in these liability waivers can facilitate unhealthy power dynamics wherein insufficiently trained plant medicine facilitators can be absolved of wrongdoing in cases of extreme negligence and or impropriety. Now, my final goal for this podcast is to warn others about Soul Quest Church of Mother Earth in Orlando. Though many in the psychedelic community recognize their name, only a few speak of the tragedies that have occurred there. During part 2 of this episode, I'll be providing in-depth analysis of DEA documents and other resources that indicate why SoulQuest has lost the trust of the ayahuasca community. Just to give everyone a better perspective, there's an ongoing silence within the psychedelic community regarding malpractice and impropriety on the part of underground facilitators and above-ground clinicians alike. On a recent episode of Power Tripping, David Nichols reminded the viewing audience that our colleagues have openly demonstrated a willingness to accept the unacceptable. While discussing Martin Ball, a psychedelic facilitator who has outright admitted to engaging in abusive practices, some of my colleagues still felt the need to defend his actions. I'll let David explain.
Seriously, we saw a number of practitioners, community members, like well-known people who, when they were pushed to give an explanation as to why they didn't think this was a big issue, they came out and said, because he doesn't have any bodies, because he hasn't killed anyone, because, you know, the difference between Martin Ball and Octavio Rettig is that Martin hasn't killed anyone. So you had people who felt comfortable saying publicly on social media, we don't think there's a problem until people start dying.
Which is a pretty fucking low bar. That's a low bar.
It's not a bar.
Yeah.
Despite this, the psychedelic community has refused to discuss the tragedy that happened on Soul Quest Church property on Easter Sunday of 2018. I ask my audience, what can be said about those who stay silent when others in our community die? So, how did it get to that point where I had to ask that grim question? For the purposes of this video, it all starts with religious freedom. And to get things going, I want to give everyone a crash course on what plant medicine churches are. For the record, they also go by the name Entheogenic Churches, plenty of others too, largely depending on the name of the organization and what quote-unquote sacrament they use. Now, for the purposes of this video, I'm going to define plant medicine churches as any organization, or rather any church, that is above ground or below ground that utilizes psychedelic substances within their official ceremonies. Now, contrary to common knowledge, there's actually a wealth of literature on entheogenic case law, that is, cases that have come before judges on this matter. Now, perhaps the most recognized of these cases would be the União do Vegetal. Back in early 2006, the Supreme Court had unanimously agreed that a small New Mexican church had the right to import and possess ayahuasca within its church services. Now, I'll actually discuss that particular case in a few minutes, so stay tuned. Now, on July 9th of last year, Michael Pollan, the author of How to Change Your Mind and This Is Your Mind on Plants, actually offered his opinion on this matter in the New York Times. I'm going to quote a small segment of his piece just to show that this is certainly no niche topic. Now, in an opinion piece called, what was it? Yes, How Should We Do Drugs Now? Pollan writes that even a hypothetical, quote-unquote, Church of Lysergic Acid could gain religious freedom because, as he put it, quote, the Supreme Court's expansive jurisprudence on religious freedom has created a wide opening through which a parade of new psychedelic churches may be able to march. He goes on to say that, quote, Americans could soon be able to go to a church to have a ritualized psychedelic experience. This is a rather interesting quote, wouldn't you say? And speaking personally, in my humble opinion, plant medicine churches are an excellent example of what I would personally consider to be the ultimate constitutional conundrum. I actually partially derived this phrase from the U.S. District Court Judge Juan Burciaga's opinion in U.S. v. Boyle, a case which concerned a bona fide member of the Native American Church who had imported peyote from Mexico to his residence in New Mexico. In his ruling, Judge Burciaga described the case as, quote, the quintessential constitutional conflict between an inalienable right upon which this country was founded and the response by the government to the swelling political passions of the day. Quite an apt description, wouldn't you say? Now, in another case, State of New Hampshire v. Mack, a member of the Oratory of Mystical Sacraments was charged with possession of psilocybin mushrooms. Though much can be said about the case, and I will spend time doing exactly that in the near future, there's a rather impressive quote that I obtained from the New Hampshire Supreme Court's unanimous ruling delivered in December of 2020. Get this, quote, sacramental use of mushrooms constitutes religious conduct motivated by a sincerely held religious belief. That's an actual quote from the New Hampshire Supreme Court. Chew on that one for a while. Now, to shift back to the general topic of religious liberties, I like to quote one of my favorite lines from the Stone Court back in the 1940s. In U.S. v. Ballard, 5 justices held that the Free Exercise Clause and the Establishment Clause explicitly prohibit judges from determining the veracity of a claimant's religious beliefs. To do so, the Supreme Court warned, would be akin to entering what they called a forbidden domain. Writing for the majority, Justice William Douglas opined that every American has the right to, quote, believe what they cannot prove. And he went on to say that religious experiences, which are as real as life to some, may be incomprehensible to others. Well, that's certainly true, wouldn't you say? Now, before we get to talking about RFRA, AIRFAA, and Florida's RFRA, let's talk about pre-RFRA case law. Perhaps one of the most important cases related to religious freedom jurisprudence would be Sherbert v. Verner. Now, this case started in 1959 when Adele Sherbert's workplace initiated a new 6-day workweek policy, and because Seventh-day Adventism, her religion, forbade her from working on the Sabbath, she refused to comply with the workplace schedule and was fired from her job. When she went to file for unemployment benefits, the state of South Carolina refused her claim. Upon appeal in 1963, the Supreme Court ruled in her favor and established what is now known as the Sherbert test. It is a 3-pronged test wherein first, it questions whether a law or policy imposes a substantial burden on a claimant's right to freely exercise their sincerely held faith. And second, if there is a burden, whether the state's interests are truly compelling. And third, if the policy or law is narrowly tailored and the least restrictive means to achieve this interest. After Sherbert broadened religious freedoms for Americans in the 1960s, the infamous Timothy Leary actually utilized the Sherbert ruling to his advantage while fighting federal cannabis possession charges. In defense of these felony charges, Leary claimed in open court that I'm going to be quoting the U.S. Court of Appeals for the Fifth Circuit here. While studying in India, Dr. Leary participated in religious rituals in which marijuana was used. He was converted to Hinduism and is now a member of the Brahma Krishna sect in Massachusetts. Marijuana enables him to attain what he describes as the 3rd level of consciousness. The Hindu sect in India, of which he became a member, uses marijuana for religious illumination and meditation. He ordinarily uses marijuana less than once a week and then only for religious purposes. He draws no distinction between his religious beliefs and his scientific experimentation. If he could not use marijuana, it would not affect his religious beliefs, but he would consider it a violation of those beliefs and practices if he were denied its use." End quote. Now, while the Fifth Circuit ruled against Leary, the Supreme Court did accept the case and actually unanimously reversed the decision, specifically because of the fact that the Marijuana Tax Act, the federal cannabis prohibition at the time, was unconstitutional because it explicitly violated the Fifth Amendment. Get that. So after this, it's worthwhile to note, by the way, that Leary actually penned this really short publication called Start Your Own Religion. It's a pamphlet of sorts that had advocated for, among other things, quote, legalizing a religious cult, end quote, which aimed to, quote, import and distribute psychedelic sacraments, including marijuana, LSD, peyote, mescaline, and psilocybin, to initiated members only and for use only in their shrines. Now, let's take off our rose-tinted glasses for a minute. I remember that Timmy was largely responsible for the prohibition of psychedelics and cannabis in 1970. After the Supreme Court ruled in his favor, Nixon swept in to task his Attorney General to write some comprehensive drug legislation that we now know as the Controlled Substances Act. This was all because, well, largely because of Leary. Now, when politicians caught wind of Leary's antics, his self-described cult, psychedelic research quickly became conflated with the lifestyles and philosophies he promoted. Really unfortunate case. You know, Leary gets too much attention as it is, so let's shift over to a more important topic. Because we're talking about entheogens and the law, it would be most appropriate to discuss the history of the Native American Church. And simply put, the Native American Church has paved the way for entheogenic churches to gain legal protection in the United States. Now, after a century of injustice, the Native American Church and other indigenous pietist congregations were thrice granted federal protection to utilize peyote, once in 1965, again in 1971, I believe, and again in 1994. Now, for quick reference, the 1971 DEA exemption permits bona fide, quote, members of the Native American Church, end quote, to possess, consume, and transport peyote, while the 1994 law extends the same protections to members of federally recognized Native American tribes. So, while there's a wealth of information on this topic in particular related to the Native American Church and other indigenous pietist faiths, to help save everyone some time, I'm including a link for an article that I wrote for Indigenous Peoples Day in 2021, an article which covered the numerous legal struggles endured by the Native American Church to protect their right to consume and possess their sacred medicine. As you will read in the article, I discuss Quanah Parker, the Hayden Bill, the case of People v. Woody, David Clark, Employment Division v. Smith, and the American Indian Religious Freedom Act amendments of 1994. I encourage my audience to check it out. Now, just as well, I've also discussed the intersection of entheogens and religious freedom on the Living Mirrors podcast with Dr. James Cook, so feel free to check that out as well. I'm leaving both links in the show notes below. Now, the most important of these cases by far is Employment Division v. Smith. That was a case which nearly eradicated religious liberties back in 1990. So, this case involved two drug counselors who were out in Oregon. They had been fired from their jobs because they had ingested peyote within ceremonies that had been officiated by congregations of the Native American Church. To be clear, they were never charged by the state of Oregon with violation of their drug laws. They had filed for unemployment compensation. It was denied. They appealed. They won. The state of Oregon appealed. Got all the way to the Supreme Court of Oregon, and the Supreme Court of Oregon actually twice ruled in their favor, but by the time that it got to the Supreme Court in late 1989 for oral arguments on Al Smith's 70th birthday, well, dark times were around the corner. Released in April of 1990, Justice Antonin Scalia's self-penned ruling in Employment Division v. Smith simultaneously legitimized anti-pietist sentiments while massively rolling back First Amendment protections. Unfortunately, his jaundiced reasoning in Smith left an indelible mark on religious freedom. As the late Justice Scalia put it in his opinion, the acceptance of foreign religious practices which defy cultural norms would result in the nation, quote, courting anarchy, end quote. Specifically because, had they ruled otherwise, quote, it would open the prospect of constitutionally required religious exemptions from civic obligations of almost every conceivable kind. Simply put, religious organizations across the nation were disheartened over the Smith decision, and this was a level of distress which ultimately led to the genesis of the law that we now know as the Religious Freedom Restoration Act, or RFRA. Why were mainstream religious groups so concerned about the fate of religious liberties? Well, this next story has something to do with it. In 1987, the Church of Lukumi, Babalu, a Florida-based Santeria church, had faced, we can call it opposition, from the city of Hialeah. It was more than opposition. They had criminalized their practices, is what happened. Specifically, the city of Hialeah was distressed by the fact that that church had employed animal sacrifice within its ceremonies, and in response, the city council had passed 3 citywide ordinances which had targeted the church by prohibiting the sacrifice of any animal within any, quote, public or private ritual or ceremony, end quote, which was, quote, not for the primary purpose of food consumption, end quote. That's how the ordinances were drafted, essentially. Now, after a series of losses, the small church actually fought its way to the Supreme Court in the early 90s, and in a surprise turn of events, our nation's highest court ruled that while animal sacrifice may indeed be, quote, abhorrent to some, end quote, they unanimously ruled in favor of the small church and agreed that Hialeah had written ordinances which were, quote, contrary, end quote, to the spirit of the First Amendment. The last 2 lines of their opinion will come into play later, so take a moment to let these words soak in. Quote, legislators may not devise mechanisms, overt or disguised, designed to persecute or oppress a religion or its practices. The laws here in question were enacted contrary to these constitutional principles, and they are void. So, because of the fact that the Supreme Court was constantly changing the goalpost on cases related to religious liberties at this time, really came down hard in Smith, and now they're saying, okay, yeah, animal sacrifice here in Lukumi. Well, Congress expedited their efforts on passing comprehensive federal legislation which aimed to restore the ruling in Sherbert. Side notes, just a few months before the decision in Lukumi was released, then Representative Chuck Schumer had introduced the bill within the House of Representatives. Used to be a representative, but let's switch gears here and now talk about RFRA, because that's one of the major talking points here. That law came about largely because of the jaundiced reasoning within Employment Division v. Smith. It passed Congress with near unanimous support in late 1993. It was signed into law by Bill Clinton, and it allows for burdened religious practitioners to, quote, obtain appropriate relief, end quote, by citing the text as an affirmative defense to a criminal charge or an avenue to bring the federal government to a civil trial. Though the law is associated with conservative movements, as I told you, the bill was actually introduced by then Representative Chuck Schumer and Senator Ted Kennedy. Now, the main message of RFRA is this: federal statutes which burden the free exercise of sincere religious practices may stand only if the government meets the burden of proof in demonstrating a justifiable and compelling interest which cannot be served by a less restrictive means. Now, if that sounds familiar, that's basically a reiteration of the Sherbert test. That's what it aimed to do. Remember the word restoration? They had to restore it because terrible things happened in Smith. Now, before signing the law on the South Lawn of the White House, President Clinton had reminded our nation of its idealistic vision to safeguard what he called, quote, our most precious, end quote, liberty, religious freedom for, quote, all Americans of all faiths, end quote. Though RFRA does not define what constitutes a, quote, compelling governmental interest, end quote, which can, quote, substantially burden, end quote, one's right to freely exercise their faith, the origin of the phrase can be traced back to the Supreme Court's rulings in Sherbert v. Verner and another case, Wisconsin v. Yoder. These landmark cases establish that, quote, only the gravest abuses endangering paramount interests, end quote, can justify the denial of, quote, legitimate claims to the free exercise of religion. So, now that we've talked about RFRA, let's talk about AIRFAA. That's kind of call it RFRA's cousin. Now, just around the same time that RFRA was signed into law, the federal law known as the American Indian Religious Freedom Act Amendments of 1994 attempted to remedy the devastation that was left in the wake of Justice Scalia's decision in Smith. Now, whereas RFRA was designed to protect, as President Clinton put it, all Americans of all faiths, AIRFAA was written so as to protect indigenous pietist faiths regardless of affiliation with the Native American Church. Now, to be clear, AIRFAA does indeed benefit and protect the Native American Church. They often cite that piece of legislation when they discuss their freedoms. Now, AIRFAA allows bona fide members of any federally recognized, quote, tribe, band, nation, pueblo, or other organized group or community, end quote, of Native Americans to use, possess, and transport peyote across state lines so that it may be utilized within religious ceremonial settings. It remains the law of the land and protects the rights of hundreds of thousands of Native Americans in their ability to consume peyote, a living sacrament that many Native American church congregations consider to be a, quote, ancestor, a living relative, a deity, and even, quote, the flesh of God. Well, some put it that way at least. Now, given that 22 states had not passed laws which had conformed to the DEA's peyote exemption for the NAC at the time of the that RFRA was passed, AIRFAA's verbiage made it clear that, quote, the lack of adequate and clear legal protection for the religious use of peyote by Indians may serve to stigmatize and marginalize Indian tribes and cultures and increase the risk that they will be exposed to discriminatory treatment, end quote. Now, in order to bring those 22 states into line, into conformity, rather, with the DEA exemption, AIRFAA proclaimed that, quote, the use, possession, or transportation of peyote by an Indian who uses peyote in a traditional manner for bona fide ceremonial purposes in connection with the practice of a traditional Indian religion is lawful and shall not be prohibited by the United States or by any state. No Indian shall be penalized or discriminated against on the basis of such use, possession, or transportation. I'll repeat that. Shall not be prohibited by the United States or by any state. Now keep that phrase in mind. You'll see where it comes into play. So only 6 years after the passage of RFRA, the law would face its ultimate test, whether or not it could protect the very practices that led to its genesis. In May of 1999, the DEA performed a raid on a small church in New Mexico. Unaware of the fact that this church was a branch of an international religion called the União do Vegetal, they seized 30 gallons of sacramental ayahuasca that was going to be used within their ceremonies. Now, in fear for the survival of their faith, the church filed a complaint for a declaratory and injunctive relief with the hopes that they might regain the right to use their sacrament within their ceremonies. After 3 long years, the conservative chief judge of the United States District Court of New Mexico, James Aubrey Parker, had granted the church's preliminary injunction with a 31-page opinion. This was a momentary victory, folks. Mind you, this ruling did not allow the UDV to drink ayahuasca. After a series of victories in the 10th Circuit Court of Appeals, the case finally made its way to the Supreme Court. And in early 2006, the Supreme Court had announced that they had unanimously agreed that the Religious Freedom Restoration Act permitted the UDV to import and consume ayahuasca within their religious ceremonies. In their ruling, the Supreme Court laid waste to the false assertion that sacramental ayahuasca is far too dangerous of a substance to be fit for human consumption, as suggested by the verbiage of Schedule 1 of the Controlled Substances Act. Under the standard of strict scrutiny mandated by RFRA, the UDV court ruled that, quote, the government's mere invocation of the general characteristics of Schedule 1 substances, end quote, found within the CSA, quote, cannot carry the day. Specifically, the Supreme Court ruled that while it's true that DMT was indeed placed in the strictest category of controlled substances, this fact did not amount to a compelling interest, which relieves, as they put it, quote, relieves the government of the obligation to satisfy their side of the Sherbert test. Now, there was another ayahuasca case that's worth discussing. A few years after that victory in the Supreme Court, the Church of the Holy Light of the Queen, a Santo Daime congregation in Oregon, had also won their right to utilize ayahuasca within their church services. Now, Santo Daime and the UDV are two distinct religions. I want to be clear. It is true, though, that they do happen to center around the use of sacramental ayahuasca. Both organizations call that substance different terms, by the way. The UDV calls ayahuasca huasca, while the Santo Daime faith calls ayahuasca daime. Fun fact. So, moving forward, like I said, they won their right to possess and transport their sacrament as well. So the Santo Daime and UDV are the only two ayahuasca churches at the moment who have federal protection to, again, utilize that sacrament within their ceremonies. So before I get into my critique of Chacrunas and the Council for the Protection of Sacred Plants RFRA Guide, I need to discuss a topic that the psychedelic community is woefully unaware of. To my knowledge, I am the only person in the psychedelic community who has written extensively on this topic, this upcoming topic, so get ready to hear something you haven't heard before. So, RFRA was passed in 1993, but I bet you're wondering why there's nearly 24 states that have enacted their own state RFRAs, right? These are actually called mini RFRAs, and Florida has one too. Let me tell you about it. It was actually enacted in June of 1998, and it was designed to prevent state laws from infringing upon the rights of Floridians to freely exercise their sincerely held religious faith. Simple, right? Florida's version of RFRA came into being shortly after the landmark Supreme Court case of City of Bern v. Flores. In this 6-3 decision, our nation's highest court held that the federal RFRA could not constitutionally be applied to state laws. and in effect, this ruling forced states to pass their own versions of RFRA, now lovingly called mini RFRAs, if they wished to afford the same protections to their citizens. Heralded by many as another victory for religious freedom, Florida's RFRA, also known as FRFRA, allows for similar protections which RFRA covers, largely because of the fact that they share near identical verbiage. Despite this success, two of FRFRA's juxtaposed positions endanger innumerable Floridians who consume entheogens as a part of their sincerely held religious faith. Among other arguments, I will establish how FRFRA's non-neutral provision harbors masked hostility towards faiths which incorporate entheogens as sacraments. Plainly put, the state of Florida is not at liberty to codify a religious gerrymander which, quote, passes judgment upon or presupposes the illegitimacy of religious beliefs and practices, end quote. For reference, this quote was from Masterpiece Cake Shop, the Supreme Court case back in 2018. The term religious gerrymander, by the way, fun fact, comes from the 1970 case of Frederick Walls v. Tax Commission of New York City. Now, in June of 2021, the Supreme Court offered a excellent description of non-neutrality while discussing Philadelphia's foster care system. In their unanimous decision, they remarked that, quote, the government fails to act neutrally when it proceeds in a manner intolerant of religious beliefs or restricts practices because of their religious nature, end quote. Now, embedded near the end of FRFRA, its two problematic provisions serve as the foundation for what I have termed this religious gerrymander. Found within the third subsection of the fifth section of the law, the neutrality provision of FRFRA states that, quote, nothing in this act shall be construed to authorize the government to burden any religious belief, end quote. Essentially, that's saying that the law can't be used by the government to burden any religious belief. By itself, this provision is non-problematic and in line with the direct objective of the statute. In fact, the federal RFRA has near identical stipulations. Now, here's the rub. The next subsection subversively contradicts the last. Quote, nothing in this act shall be construed to circumvent the provisions of Chapter 893 of the Florida Statutes. Now you might be wondering to yourself, what's Chapter 893? That's actually Florida's laws regarding controlled substances. Yeah. Though I agree that efforts to limit drug misuse are necessary to ensure the welfare of the general public, we must scrutinize FRFRA's discriminatory provision to understand how it effectuates religious gerrymandering. For those who are quick to defend this unconstitutional provision that I just mentioned, I wish to remind my audience that Florida is well known for its history of enacting policies, laws, and regulations which prohibited a variety of constitutionally protected practices. Want proof? Just crack open a history book. The Interposition Resolution and the Johns Committee are great places to start. To borrow the words of Justice Anthony Kennedy, FRFRA's most, quote, severe consequence, end quote, inherently, quote, imposes a broad disability, end quote, upon certain Floridians who wish to gain, quote, legal protection from injuries caused by discrimination, end quote, based upon their sincerely held religious beliefs. Fun fact, these exact words came from the Supreme Court's ruling in Romer v. Evans. In 1996, the Supreme Court overturned a state's constitutional amendment, known as Amendment 2, which completely prohibited any governmental action which recognized, quote, homosexual, lesbian, or bisexual, end quote, people as a protected class. Now, though America lived in an age of rampant homophobia, the Supreme Court found that Colorado's recently passed amendment violated the Equal Protection Clause. Among other qualms, the court ruled that Colorado's amendment was, quote, born of animosity, end quote, directed towards non-heterosexual individuals. Quoting one of their rulings from 2 decades prior, the Supreme Court reminded our nation that a, quote, desire to harm a politically unpopular group cannot constitute a legitimate governmental interest, end quote. Now, this quotation also came from the case of Department of Agriculture v. Moreno, which we'll discuss again later. To keep things in perspective, the Supreme Court remarked in the case of Personnel Administrator of Massachusetts v. Feeney that, quote, proof of discriminatory intent, end quote, evincing what, quote, any official entity is up to, end quote, can be obtained by closely examining, quote, the results their actions achieve or the results they avoid, end quote. And to this end, exactly 27 years before Florida's RFRA became law, President Nixon had privately admitted his level of respect for our nation's laws. Just an hour before going on to national television to tell our nation that, quote, America's public enemy number one is drug abuse, he told his aides that, quote, I don't give a shit about the law. Forget the law, end quote. This was on the morning of June 17th of 1971 for those who want to look into the Nixon White House tapes. Now keep something in mind as we talk about FRFRA here. In the UDV case, the Supreme Court had pointed to the actual text of RFRA and unanimously agreed in their decision about, quote, the fact that the very reason Congress enacted RFRA was to respond to a decision denying a claimed right to a sacramental use of a controlled substance, end quote. Any lingering doubts about the genesis of RFRA can be set aside after one actually listens to the oral arguments from that case. 15 minutes into the recordings, Justice Scalia had plainly admitted that, quote, Congress didn't like Smith and has enacted this statute, RFRA, obviously to undo, to the extent it can, the effect of our judgment in Smith. Honestly, that's the only admission of guilt I've ever heard Justice Scalia heard from him regarding his ruling in Smith. If anyone is familiar with instances where he actually discussed his ruling in Smith at any length, I'd love to hear them. Anyway, getting back to the point. Actually, quick side story. He actually went on I remember now. He went on C-SPAN once to talk about Alfred Smith and Galen Black, and he described the two of them as the type 2, and this is a loose but fair paraphrasing, that Alfred Smith and Galen Black were the types to, quote unquote, go off into the mountains every weekend and smoke peyote. Shows his level of appreciation for the topic, wouldn't you say? Now, during the oral arguments for Employment Division v. Smith, former Oregon's Attorney General David Frohnmeyer had plainly admitted that the state of Oregon had pending cases, especially State of Oregon v. Verner, which involved what he called, quote, sincere religious communicants who believe that their use of marijuana is religiously inspired and have asked for exemption from Oregon's drug laws. And that's part of the problem, end quote. Now, Justice Scalia heard this and immediately responded by ringing that good old dog whistle of his and had asserted the unconstitutionality of affording certain churches legal protection to ingest peyote, but prohibiting other, quote, religions to use marijuana or any other hallucinogenic drug. Isn't that a problem too? Question mark. Now, such rhetoric subtly implied that affirming Oregon's ruling in Smith, that is the Oregon Supreme Court's ruling in Smith, that is ruling in favor of Alfred Smith and Galen Black, affirming that ruling could potentially leading substance users to claim that their religious liberties were burdened by laws prohibiting the possession of various controlled substances. Now, this slippery slope rhetoric ultimately proved fruitful for David Frohnmeyer when Oregon's Court of Appeals cited the Smith ruling when they denied Vinay's claims for a religious exemption back in 1991. Again, he was the person who was trying to get the religious exemption for cannabis. Since we're still talking about the Smith decision, it's good to remember that Justice Scalia had lamented in his decision that the utilization of a balancing test in cases concerning religious liberties would, as he put it, quote, open the prospect of constitutionally required religious exemptions from civic obligations of almost every conceivable kind. Now, lest we forget, Florida's RFRA has overly broad language, which can potentially protect any act in accordance with one's religious beliefs. Though this statement may appear to be an exaggeration, the language of the statute is by no means ambiguous. If you look at the law itself, Florida's RFRA says that the law applies to, quote, all, end quote, state laws, and protects any, quote, exercise of religion, whether or not the religious exercise is compulsory or central to a larger system of religious belief, end quote. So, essentially, Florida's RFRA allows Floridians to request exemptions of almost every conceivable kind, just like Scalia was talking about, unless their faith has been endangered by Florida's controlled substance laws, right? So, to put it bluntly, Florida's RFRA effectively forbids innumerable Floridians from obtaining statutory protections which, quoting the ruling in Romer v. Evans, quote, others enjoy or may seek without constraint. Now, because of the stark language of FRFRA's anti-drug provision, the law's overall neutrality is facially questionable, and it leads one to ponder whether or not it was included so as to serve as an assault on a variety of world religions which utilize entheogens as sacraments. Now, of the nearly 24 states which currently hold mini RFRA style laws, Florida is the only one which explicitly seeks to prevent entheogenic faiths from seeking legal protection. I have checked literally every other mini RFRA that is out there, and Florida is the only one that prohibits the law from being used to as FRFRA puts it, circumvent the state's drug laws. So remember Romer v. Evans? In that case, the Supreme Court had ruled that any set of statutes which makes it, quote, more difficult for one group of citizens than for all others to seek aid from the government is itself a denial of equal protection of the laws in the most literal sense. That's pretty plain language, wouldn't you say? Justice Sandra Day O'Connor had remarked in her concurring opinion in Employment Division v. Smith that statutes which explicitly criminalize a citizen's, quote, religiously motivated conduct burdens that individual's free exercise of religion in the severest manner possible, end quote. Citing another case called Braunfeld v. Brown, Justice O'Connor made it clear in her concurring opinion that such prohibitions inherently force religious practitioners into, quote, abandoning their religious principle or facing criminal prosecution. In 1973, the Supreme Court had ruled that the Food Stamp Act of 1964 was unconstitutional insofar that it was not tailored to provide aid to those who lived within non-traditional communal households. Now, specifically, the Moreno Court remarked that the 14th Amendment's right to equal protection signifies, quote, that a bare congressional desire to harm a politically unpopular group cannot constitute a legitimate governmental interest. Citing the lower court's decision, the Moreno Court made it clear that any such, quote, purpose to discriminate against hippies, end quote, violates the Due Process Clause of the Fifth Amendment. Pretty plain language. The Moreno Court also remarked that such jaundiced reasoning cannot, quote, justify, end quote, statutes which effectively discriminate against those who practice lifestyles which do not conform to societal norms. You know, given that the Supreme Court unanimously ruled in favor of the UDV by utilizing the standards set forth within the Sherbert test and RFRA in the First Amendment, it's remarkable that the Florida legislature has failed to repeal FRFRA's anti-drug provision since the ruling was laid down in early 2006. Yeah, that's right. In Florida, the UDV decision apparently has no applicability whatsoever, and it's been that way now for, 16 years. 16 years. So if the Florida legislature was truly concerned about protecting Floridians from becoming burdened by state laws which prevented them from freely exercising their sincere faith, it would follow that the Florida legislature would accept the UDV ruling to the extent that the enforcement of Chapter 893 is a compelling state interest which cannot outweigh the rights provided by the state's free exercise clause. The Supreme Court has ruled that the Constitution compels the federal government and individual states to practice tolerance towards various religious sects, especially minority faiths. The Lukumi court warned that if there arose even a, quote, slight suspicion that proposals for state intervention stem from animosity to religion or distrust of its practices, all officials must pause to remember their own high duty to the Constitution and to the rights that it secures. Since the landmark UDV ruling was delivered in early 2006, the Florida legislature has continually ignored its applicability to Florida's religious freedom laws. In light of this, it would be most appropriate to echo the words of former Florida Governor Leroy Collins. Back in April of 1957, the Florida legislature, along with other states, had attempted to nullify the Supreme Court's ruling in Brown v. Board of Education by passing a resolution which asserted that Florida did not have to integrate their racially segregated schools. Soon after Florida's Senate passed the interposition resolution, Governor Collins released a public statement condemning their actions. As he put it, quote, "It is a preposterous hoax, almost laughable, to suggest that any state can remain in the Union, and yet, as if by some alchemy, isolate and quarantine itself against the effect of a decision of the United States Supreme Court." Unfortunately, Florida's RFRA goes far beyond prohibiting just ayahuasca churches. It even prohibits chapters of the Native American Church from engaging in peyote ceremonies within the state's borders. Given the lack of a statewide exemption for indigenous peyotist churches and the clear phrasing of FRFRA's anti-drug provision, Florida's RFRA certainly violates the American Indian Religious Freedom Act amendments of 1994. Remember when I mentioned that AIRFAA proclaimed that, quote, "the use, possession, or transportation, yada, 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 shall not be prohibited by the United States or by any state"? Yeah, this proves that Florida's RFRA or rather its anti-drug provision, is in clear violation of federal law. Just to provide explicit examples of this, I have two brief video clips from an excellent documentary called The Peyote Road, Ancient Religion in Contemporary Crisis. This documentary was released in the early to mid-90s, I believe, 93, what would have been 94, 95. It captured the sentiments of various Native American church congregations at a time when they didn't know what was in stake, or rather what was going to happen because of the ruling in Smith. And before AIRFAA was actually passed in 1994, there was, like I said, no comprehensive legislation that enforced the DEA's federal peyote exemption as it pertained to state laws. And given this lack of protection, members of the Native American Church and other indigenous peyote faiths were constantly in danger for simply participating in their faith. Now, before I play this clip, keep in mind that this documentary was made before AIRFAA was signed into law. Having said that, let's listen to the narrator tell the story.
In spite of the cooperative relationship between the Federal Drug Enforcement Agency, the Texas Department of Public Safety, and the Native American Church, individual states are not compelled to honor the religious freedom of Native American church members, despite the government's trust responsibility to protect and preserve Indian cultures. Since the Smith case ruling, each state is free to make its own laws. Native American church members who have lawfully acquired the peyote in Texas can still be arrested and prosecuted in states they may live in or must travel through on their way home from the Texas peyote gardens.
Now, this same documentary also features testimony from Parrish Williams, a roadman of the Southern Ponca people. And while speaking at the American Indian Religious Freedom Summit in 1991, which was held in Albuquerque, I believe, this roadman told the audience in rather clear terms that he was in fear for the safety of other members of the Native American Church. I'll let him explain.
There was a young man here just last week. He lives in Indiana. He's a member of our church, local chapter. He's got him employment in Indiana. He asked me to send him a membership card because he's a member of our local chapter. And when I thought about it, I don't know whether Indiana they legalized this peyote in their state. To send this to him, and I even sent him with some peyotes with him. If they catch him with that peyote on his person, I don't know what they will do to him. We would like to get in the 50 states of the United States where they could pass laws like giving us privilege to even just go through their state with this peyote in our possession. We would be satisfied. If they don't have no way of saying this peyote is legal in their state, we'll be arrested.
Parrish was right. He could have been arrested. Unfortunately, that's still the case for people in Florida. So now we have a situation where bona fide members of the Native American Church and other indigenous payist faiths have the possibility of being arrested if they choose to possess peyote or perform a peyote ceremony within Florida's borders. Yes, there's a federal law in place, I understand that, but if a roadman or somebody else were arrested while in Florida while in possession of peyote, they would still suffer the indignities of arrest and incarceration before the matter could be cleared up. Even then, they will have an arrest record that will haunt them and affect them for the rest of their life until it can be sealed, expunged, what have you. So, what do we do now? I had asked myself this exact question when I received an email earlier this week. I had opened my inbox and found a message from somebody who had emailed me through my website, and they had told me that they were, quote, looking up information about capital G grandfather medicine in Florida. For those who don't know, grandfather medicine is another term for peyote. I've heard it many times before. The term grandfather is especially used inside the Native American church as opposed to outside. It's a term of endearment in many ways. And after reading this email, after indicating that they were, quote, a member of the NAC church, they told me that they felt as if they were, quote, getting pulled back to capital G grandfather, period. It's been a very long time and I'm in a big transition now. I'd like to connect and ask you more about communities here for gatherings as well as possible tobacco or grandfather ceremonies if possible. Now, by this language, I can tell that the person is likely a bona fide member. Can't say for sure. The fact that they use capital G grandfather medicine makes it, argues in their favor, but at the same time, NAC Church, huh? Anyway, I had to respond by telling them that Florida's religious freedom laws explicitly prohibit these practices, and even if you come in with the sincerest of faiths and the best of practices, such practices are not protected by Florida's religious freedom laws. So, what if I were to tell you that one of the most prominent organizations in the psychedelic community wrote an 84-page guide that did a deep dive on religious freedom jurisprudence and even covered state RFRAs, but failed to see this unconstitutional provision? An unconstitutional provision which affects the third most populated state in the United States. Well, that organization would be Chacruna Institute for Psychedelic Plant Medicines. So, 2 months ago, in November, Chacruna and the Council for the Protection of Sacred Plants released their Guide to RFRA and Best Practices for Psychedelic Plant Medicine Churches for free to everyone in the community. And I have provided a link for that in the show notes below. And in conjunction with that publication, Chacruna also hosted a 2-hour-long webinar held on December 15th of last year called, quote, Protecting Sincere Psychedelic Churches, Chacruna's Guide to the Law and Best Practices, end quote. I have also posted the link for the webinar in the show notes for everyone's convenience if they want to watch it. Now, just for clarity, I'll be drawing from these two resources for my critique. While I'm aware that Chacruna owns the rights to the videos I'm about to play, please keep in mind that the principle of free use applies to academic critique of publicly available publications. And without these First Amendment protections, you'd have to see me awkwardly read off verbatim quotes from the meeting for several minutes at a time. And, well, instead, I have selected only about 2 minutes of relevant footage so that everyone can fully appreciate my critique. Having said that, I will let Dr. Bia Labache, the founder and executive director of Chacruna, describe the Council for the Protection of Sacred Plants, an organization that, according to the guide, provided, quote, contributions and feedback. Because most of my audience does not know much about the council, I'll let Dr. Labache describe it in her own words.
This council is a network of researchers and lawyers, activists, and practitioners. We have been operating for more or less 3 years. I'm proud to say that I think we are like the first hub of lawyers that are dedicated to this topic. So this council was formed before all this decrim initiative started to spread across the US, and also before the Psychedelic Bar Association or other different law firms that started to emerge in the field.
So now that we have a good understanding of the publication, I'm ready to move forward with my critique. Now, if you look at page 40 of the RFRA guide, they claim that, quote, whether a psychedelic plant medicine church's religious exercise will be protected using RFRA analysis from state or local government action depends on whether the state has adopted its own version of RFRA, charmingly referred to as mini RFRAs. On the next page, they state that, quote, ultimately, plant medicine churches and their members may have more legal clarity regarding their rights and protection for their religious exercise in the RFRA states or in those states that have adopted RFRA analysis. Now, while there is truth to these statements, the devil's in the details. If you glance at the list of 22 states that they cite as having a mini RFRA, Florida is placed 5th in the list. Now, I know what you're thinking. Florida does not have a mini RFRA that potentially protects entheogenic churches. As we covered earlier, Florida's RFRA explicitly forbids circumvention of the state's drug laws. Given that Chacruna's guide stated that Florida has a mini RFRA, it can certainly lead people to be misled on the topic, to have the misperception that Florida has such protections. They do not. As a quick side note, whoever was tasked with writing this section on mini RFRAs in the Chacruna guide unfortunately did not take the proper amount of time to read the text of Florida's RFRA, and this is clearly evidenced by the fact that Florida's mini RFRA is referenced in the guide as being codified within Chapter 76 of the Florida statutes. It's actually Chapter 761. So when I brought up the topic of Florida's RFRA at Chacruna's webinar, they had already spent about 2 hours discussing anything and everything related to entheogens and religious freedom. Quite an extensive discussion with all the panelists. To be honest, I thoroughly enjoyed it. And near the end, I had posed a question related to, this exact topic, Florida's RFRA. And as I put it in the chat window, quote, does anyone on the panel care to discuss how Florida's RFRA explicitly forbids Floridians from using the statute to, in FRFRA's words, quote, circumvent, end quote, the state's drug laws? And just left it at that. And, I was lucky enough to have Mason Marks, MD, Esquire, to field my question. And I'll actually play it for you so everyone can appreciate what was said. For full context, the clip that I'm about to play came at the very tail end of the Q&A section, so keep that in mind as we move forward.
There was an interesting question about Florida's mini RFRA and how it explicitly states that it cannot be used to circumvent Florida's drug laws. And do you have any thoughts on that? I wonder if that, RFRA, the federal RFRA, basically can overcome state laws. So, could that mini RFRA potentially violate the federal RFRA? Or is there any other way for Floridians to,
Can I say, I wanted to say something still about the other point.
Did you notice how Jack Silver was about to say something? Yeah, I did too. Unfortunately, Dr. Labate had changed the topic to one that had already been thoroughly discussed throughout the webinar, and that was whether or not churches should exclude certain people from participating in their ceremonies because of certain health conditions. I'll play her full response for full context.
Or is there any other way for Floridians to,
Can I say, I wanted to say something still about the other point, that all of these issues are super strong in Brazil too. And we have published, for example, an article by Alex Polari, who's a leader of Santo Daime in Brazil, that he's kind of claiming the religious right to treat the crazy or the, lost or the, beggar or the rejected, the people that are kind of considered lost causes.
To be honest, I'm quite perplexed how my question could have been sidestepped, given the fact that FRFRA was included within Chacruna's guide. Especially so, given that Dr. Labache had claimed only a few minutes within the webinar that Chacruna and the Council for the Protection of Sacred Plants are, quote, trying to foster the development of this field in ways that promote responsibility, ethics, accountability, transparency, and pure comment, end quote. Nearly 32 minutes into the webinar, Dr. Labache had also claimed that Chacruna and the Council for the Protection of Sacred Plants are, quote, inviting everybody to learn about this, that is, the topic of religious freedom laws, quote, to engage in the big questions, and then the details and the technical parts aren't so challenging. Well, I wanted to engage in the technical parts and the details, but I was kind of shot down. Just for added context, 50 minutes into the webinar, Allison Hoots, one of the primary authors of the RFRA guide, had reminded the viewing audience that certain courts will analyze claims in a more conservative way, as she put it, an obstacle which requires plant medicine churches to base their RFRA claims on what she called the, quote, accepted frameworks, and if they wish to gain legal protection. The full quote, for context, is as follows. Quote, you do have these agencies and these courts that are going to analyze RFRA claims in a more conservative way. So being able to articulate based on the accepted frameworks is going to be advantageous if you're trying to assert a RFRA defense or file a RFRA claim. Now, at 74 minutes into the webinar, Dr. Labache had asked Jack Silver about the question that she believed, quote, everyone has. Just for everyone's reference, Jack is one of the attorneys who had represented the Oregonian Santo Daime churches in the late 2000s. Very skilled, knowledgeable lawyer. I can say many great things about him. Point being, getting back to the hypothetical question that Dr. Labache had posed, she had said, quote, okay, I have a church, I'm operating, I'm fine. Should I keep quiet? Should I try to incorporate? Should I try to go above ground? Should I wait for the Church of the Eagle and the Condor or a Soul Quest? Others go and crash themselves and I just follow? What's your advice? And Jack responded by saying that, quote, it's a case-by-case analysis. So, again, I'm in California. California does not have a RFRA statute, or a mini RFRA as they call it. And so generally, the federal government, even though they did that with Jonathan Goldman of the Santo Daime Church and with Jeffrey Bronfman of the UDV, they don't get involved in the arrest. They usually turn that over to local law enforcement. So then you're fighting in your state to determine whether or not they, that is the local law enforcement, violated it, meaning the First Amendment or the mini RFRA in question. So, given that federal authorities usually handle cases like these over to state police, mini RFRAs become especially important. Only a moment after making the statements, Jack followed up by saying that, quote, it really depends on where you are. Again, I practice in environmental law in Northern California, and every once in a while I read a case out of Texas and I think, oh, thank God I'm not in Texas, so it really depends on the circumstances. And, you know, that's pretty relatable. I'm always asking myself why I still live in Florida. But point being, I hope this critique inspires Chacruna and the Council for the Protection of Sacred Plants to amend their guide, to exclude Florida from their list of states with mini RFRAs, so as to not potentially mislead any readers. I would be more than happy to collaborate with them on a potential chapter or section regarding Florida's RFRA and the need to abolish its anti-drug provision. Point being, if the psychedelic community just ignores this blatantly unconstitutional provision within Florida's RFRA, then Florida's plant medicine churches will continue to serve as low-hanging fruit for law enforcement officials. Mark my words. Now, there's an even more serious issue within Chacruna's RFRA guide that needs to be addressed. Specifically, I'm talking about their suggested contents for liability waivers to be potentially employed by plant medicine churches. The suggested contents for these liability waivers, in my humble opinion, could facilitate unhealthy power dynamics wherein insufficiently trained plant medicine facilitators could be absolved of wrongdoing in cases of extreme negligence and or impropriety. Before we get going on this topic, I'd like to note that, as far as I'm aware, any such liability waivers that are predicated upon one or more parties distributing a controlled substance to be ingested would be void for illegality. Whether or not we like to admit it, the distribution of a controlled substance is indeed an illicit act in, as far as I'm aware, every part of the nation except those where decrim statutes are in effect. I may be wrong on that. Do not cite me on that. Point being, if I am sorely mistaken on the matter, I would love to hear a dissenting opinion. Now, getting back to the critique, I humbly disagree that plant medicine churches should compel congregants to, as the RFRA guide suggests, quote, assume all risks, end quote, of participating in a plant medicine ceremony, risks which would include, quote, illness, disability, or death, period. For Chacruna and the Council for the Protection of Sacred Plants to suggest that such aggrieved parties and their families be, quote, barred from recovering damages, end quote, in situations where people suffer disability or death would, in my humble opinion, be a terrible example of psychedelic justice. Often those who visit plant medicine churches attend so as to address various health conditions, many of which are psychological in nature. Keep in mind that these desperate, vulnerable populations are looking for a quote-unquote legal means of obtaining a psychedelic substance which may afford them healing, yet at the same time also carries risks. Mind you, I am not misusing the terms desperate or vulnerable here. These exact words happen to have been utilized by Soul Quest officials to describe their congregants. You'll hear me talk about that in part 2 of this podcast, the next installment. Now, if plant medicine churches follow the advice of this RFRA guide in regards to the liability waivers, it would put, in my humble opinion, far too much power in the hands of plant medicine facilitators, many of whom operate without medical licensure in a community which suffers from a dearth of watchdogs and meaningful regulation. Plant medicine churches are supposed to provide participants with a safe environment where they can rest easy, knowing that they are being taken care of by the facilitators. Liability waivers such as those described in the RFRA guide, in my humble opinion, raise more questions than they answer. I'll provide all the pertinent quotes from the RFRA guide to help in validating my claims for those who have questions or concerns. Although the language that you're about to hear is plain at times, consider the implications. On page 66 of the RFRA guide, it is stated that plant medicine churches, quote, must prepare for the unexpected, including a congregant having a difficult experience or a medical emergency. In a worst-case scenario, a congregant or the family of a congregant who is severely injured or dies may be compelled to file a lawsuit against the church. 2 pages later, on page 68, it is stated that, quote, a ceremony release needs to define any and all risks of attending a ceremony in order to have the congregants knowingly assume the risks, period. Assumption of risk means that an individual, having voluntarily exposed themselves to the known risks, is barred from recovering damages for an injury sustained in the course of the described activities. If the congregants assume the risks, then the congregants may not be owed a legal duty that would be the basis of a successful lawsuit. In explaining the risks to congregants, the church needs to include in the ceremony release that, for example, a ceremony can involve physical, financial, property, emotional, and other damages, losses, or personal injury, including, but not limited to, illness, disability, or death, to the congregant or other congregants, which can be caused or complicated by the congregant's mental, physical, or emotional health or conditions during the ceremony. That's a mouthful. They go on to say that, quote, "It is best to be as thorough as possible, even if it seems lengthy, because the church only has one opportunity for the congregants to consent and, by assuming all risks, release their right to any legal claims against the church." End quote. On the next page, on page 69 of the guide, it is also stated that, quote, "After detailing the risks of participation and noting there may be unknown risks, the congregant would be able to agree to assume any and all risks." End quote. One page later, on page 70 of the guide, it is suggested that, quote, "Congregants agree to certain conditions," end quote, including being able to, quote, "accept responsibility for the costs of any medical attention or services that the congregants may need," end quote, related to the ceremony in question where damages were sustained. So, let me ask you this. What if the Johns Hopkins Psilocybin Research Group compelled study participants to sign liability waivers which absolved the organization of liability? God forbid someone were to hypothetically experience a serious adverse drug reaction to their pharmaceutical-grade psilocybin. What if the local church wanted to take Sunday schoolers on a field trip and made parents sign a waiver saying that the church couldn't be sued, God forbid something terrible happened to their children during the field trip? Alarm bells start going off, right? Now, I'm sure I already have critics readying their responses, saying that such liability waivers are necessary for plant medicine churches. Well, like I said in the beginning of the podcast, while I agree that liability waivers can properly inform congregants of risks associated with attending such ceremonies, I humbly disagree that such liability waivers include verbiage that prevents such aggrieved parties from recovering damages in cases of illness, disability, or death. But point being, I'm sure I have critics lining up to ready their responses, but you know what? I have proof that these sorts of liability waivers have already effectuated harms. You want to hear the proof? You'll have to tune into the second installment of this podcast when it comes in a few weeks' time. Now, before I wrap things up, I want to thank everyone who has helped make this podcast possible. If you enjoyed this production and if you want to support my work, please feel free to subscribe to this YouTube account, smash that like button, and stop on by Patreon to check out my page. I'm over at patreon.com/Sasha Cisco. You can support me there. I'm also on Twitter at Sasha Cisco, so feel free to follow me there as well. Again, thanks to everyone for tuning in, and I'll catch you all on the next episode of the Ultradelic podcast. Until next time.